Ningo Pram's Member of Parliament Samuel Nate George has expressed surprise at the Supreme Court's decision to prioritize the case of South Dai MP Roxanne Nelson Dafiamekpo over that of private legal practitioner Richard Delaskai. Richard Delaskai filed an application on March 5 with the Supreme Court seeking a declaration that the Human Sexual Rights and Family Values Bill, commonly known as the Anti-Gay Bill, is now void and of no effect. The Ningo Pram MP argues that the court's proceedings would have been more equitable if it had heard the case concerning the anti-gay bill before addressing the South Dai MP's case.
What is surprising me is that the Chief Justice has not called the Richard Sky case, which is almost 4 weeks old, before the court, to hear that, but has called the case that was less than a week old, because it's the same principle. Because the principle the Supreme Court has espoused here, if you apply that to what is the Richard Sky case, that case also has to be thrown out because it's equally very frivolous. Because the Supreme Court has no power to stay the hands of the president. But if the judiciary is not being biased, if the judiciary is showing a mind of its own, especially the Chief Justice, showing a mind of their own, they would have called both cases. Because, common sense is a part of legislation and the work of the judiciary. You would only expect that a case that preceded the Roxanne Dafiamekpo case would have been heard, if not at the same time, before.